What brownfields buyers need to know. What brownfields buyers need to know about state level variations. The federal liability protection for brownfields purchasers is well established in principle. How states have implemented it in practice varies enough that buyers relying on a general understanding of the BFPP defense may be carrying more exposure than they realize. When Congress passed the Small Business Liability Relief and Brownfields Revitalization Act in 2002, it created a pathway for non-polluters to acquire and redevelop contaminated property without inheriting the full weight of CERCLA's strict, joint, and several liability scheme. The bona fide prospective purchaser, BFPP, defense was intended to unlock a market that the original 1980 law had inadvertently frozen by making industrial property too legally dangerous for new buyers to touch. That freeze had real consequences. The fear of open-ended CERCLA liability pushed investment away from inner-city industrial sites toward undeveloped greenfields, accelerating suburban sprawl and leaving urban cores with what became known as brownfields. More than 2 decades after the 2002 reform, those liability protections are working, but inconsistently across state lines. How the federal BFPP defense works and where it falls short. To qualify for federal BFPP protection, a buyer must acquire property after January 11, 2002, conduct all appropriate inquiries, typically satisfied through an ASTM-compliant Phase 1 environmental site assessment, have no affiliation with any responsible party, and take reasonable steps to stop continuing releases and prevent future ones. The buyer must also cooperate with remediation access and institutional controls. The defense has documented gaps. It does not apply to stock purchases, where the acquired company carries its pre-existing environmental liabilities through the transaction regardless of the buyer's intent. Courts have also held that on-site soil movement during construction, such as excavation and grading, can constitute a new act of disposal under CERCLA, defeating a defense that was valid at acquisition. And Phase 1 assessments expire. A report older than 1 year requires a full new assessment, and certain sections require updates after 180 days. The Ashley 2 case from the District of South Carolina illustrated the cost of partial compliance. A buyer commissioned Phase 1 assessments, identified a contaminated wastewater system as a recognized environmental condition, undertook remediation elsewhere on the site, but failed to address the wastewater finding. The court found that failure constituted a lack of appropriate care and denied the BFPP defense, exposing the buyer to full liable party status. How North Carolina, Utah, and California structure their state programs differently. North Carolina does not offer a BFPP defense at all in the traditional sense. Instead, prospective purchasers who did not cause or contribute to contamination enter the state's Brownfields program under the 1997 Brownfields Property Reuse Act, which provides a covenant not to sue from the state DEQ, transferable property tax incentives on a graded 5-year scale, and land use restrictions that run with the land to all future owners. The program has produced more than 770 agreements representing over $30 billion in investment and more than 14,000 acres returned to productive use. Utah takes a different approach through its enforceable written assurance, administered under the state's Hazardous Substances Mitigation Act. The EWA provides state-level cost recovery protection only, not a federal CERCLA defense, and requires a $500 application fee plus hourly charges for staff review time beyond the initial fee. It is a pre-acquisition tool that typically takes approximately 60 days to process with a complete application. Utah's DEQ has issued 176 EWAs since the program rules were adopted in 2005, with the program credited with supporting hundreds of millions of dollars in redevelopment investment. California enacted the California Land Reuse and Revitalization Act in 2005, modeled on the federal framework, but providing broader civil immunity that covers liability for cleanup costs imposed by the state or third parties, contribution claims brought by other potentially responsible parties, and natural resource damage claims. California's DTSC charges program fees of approximately $50,000 to $150,000 or more, depending on site complexity, and immunity attaches at agreement execution rather than at the conclusion of cleanup. what EPA appropriate care guidance updates could change. Practitioners at the April 30th ASTWMO webinar flagged that EPA was indicating at its 2025 Brownfields conference that updated guidance on the appropriate care component of the BFPP defense was in development. The appropriate care standard is the element that most often defeats an otherwise valid defense when buyers fail to address recognized environmental conditions identified in Phase 1 assessments, as the Ashley 2 case demonstrated. Updated guidance would be relevant for any buyer, legal team, or EHS function managing contaminated property acquisitions. You've been listening to Sustainability Soundbites by Environment and Energy Leader. For partnership opportunities, please reach out to our team.